the easiest if you could introduce yourself.
Okay. My name is Carey Linde. I've been a lawyer for 34 years. The last 10 years have been exclusively in family law. 98% of my clients are fathers. Some of my most difficult case ever was acting on behalf of a mother whose ex-husband had psychologically kidnapped her two daughters from her. My philosophy is equal time shared parenting. I help basically children, is what I like to think I'm doing, have equal time, or certainly if not 50-50, which is sort of not necessary, but substantial time with both parents. Unlike many lawyers, perhaps all lawyers, I would probably go so far as to say that there are clients I will not act for. I won't help a parent try to deny children to the other parent in a way which I personally, by my ethics, think is unreasonable. I'm criticized by lawyers a lot for that, who take the position that a lawyer should help anybody who comes in the door and has the money to pay for it. I never bought that. I think that the majority, and perhaps again I could probably say all family law lawyers that I've ever heard of or know, to some extent, most to a great extent, are unethical and hypocritical in the way they deal with people. I know I'm talking longer than you wanted me to, but
No, but you're stopping, so it's possible to cut in between.
Let me just tell one more little clip. I had taken a couple of years off of law before I came back in to do this gig, and got involved with a lot of men's organizations and meetings, and met and spent a fair amount of time listening to and with Robert Bly and some of the people in that of that talent. And when I came back and decided that I would go into family law, having previously been a litigator in corporate and commercial litigation, court-oriented, in other words, I remember being amazed at two things. One was that I went over and listened to sat in some courts, and I heard about this phrase, the primary parent. And children were being awarded to mothers left, right, and center because they were the primary parents. So I went to the library to research, naive as I was back then, not having done family law, that there must be a case somewhere which establishes that a primary parent, first of all, what does it mean on an empirical basis? There has to be some evidentiary support for it because the law is based on evidence. Well, not only did I not find anything that says that primary parent has any meaning, the contrary or an unstated fact is known everywhere, and that is that fathers are as equally important. And there's no evidence to suggest that when children grow into their teens or young adulthood, that it makes any difference whether they were raised by the primary parent as opposed to the so-called secondary parent. The other thing that I quickly caught on to, where this idea of hypocrisy comes in, is that I remember a lawyer in Vancouver getting up representing a father and saying that he wanted more than every other weekend and Wednesday nights with his two young kids because that was good for the kids. And then did or didn't get what I think it was a woman, what she wanted, sat down, and within about a half an hour, she had another case come up. And here she was acting for the mother, trying to prevent the father from having reasonable time. And the facts were basically just the couples were just ordinary people trying to do the best they can in a crazy world. And so you either believe that children need both parents or you don't. And there's no compromise in there.
That's excellent. You've actually answered several of the questions I had listed, but that's not surprising since these were based on our past conversation. What motivated you to become so focused on representing fathers? Was there one specific incident, or was it a time in your life? Or?
Well, as I said, I had been doing law for 20 years, and the last 10 of them were in court a lot around corporate and commercial litigation, which means that it's court work. Everything is done on the basis of witnesses and evidence, and you have to support what you propose. And then I took 2 years off. I saw an escape route. Lots of lawyers wish they weren't practicing law, and I had an opportunity to go to work for the client, doing creative work on computers and doing up ads and traveling around and doing things in Greyhound bus terminals, and it was fun. It was 2 years. And then that came to an end, and I didn't have any money, so I had to come back in. But in that meantime, I had, as I say, become involved and attended with a lot of conferences around mainly men and subsets of fathers from within that. And I had my own so-called midlife crises, multiples, that I was dealing with in that time. And while I was in these various places and at these various conferences and workshops and retreats, people would hear that I was a lawyer, and they would ask me all these matrimonial law questions, thinking I would know all the answers, which I didn't. So when I came back in and I had to figure out what to do, it made sense to try to work around men's issues, legal issues, which I had become so aware of. And there is a dearth of any help out there. There's nothing, absolutely nothing. I mean, if you look at the yellow pages of any city, you'll see a full page of organizations which help women, which is terrific. And you might find 1 or 2 entries that help men. You know, they just, for some reason, my gender just hasn't been able to get to it. So I came back in looking at the issues around men, but there's no way you can make a living around some of those things. And it quickly ended up I was acting for fathers. And that immediately made me understand that it really wasn't the parents who were the people you wanted to help, it was the kids. But I can't go off and get paid by children, although I have on some occasions. That's another couple of interesting stories somewhere where I have acted for kids who would give me $1, and there's a solicitor-client relationship, and away we go.
You were talking about, and this was one of my later questions, but I'm going to ask it now because you touched upon it. Is there such a thing as a divorce industry? Do you think there are people who take advantage of divorce and people's troubles? You were saying that you thought a lot of lawyers were unethical in the way that they handle.
Yeah, whether or not there is a divorce industry per se, I wouldn't say that as such. I mean, if there is, it's created by the circumstances of life. I mean, people separate. There are a lot of experts who can help you, who will make money on their being paid to give their opinions as to how best to divide up assets if you have assets. But the majority of people don't have the need to divide $1 million up and have tax consequences. Working class people, who are essentially the basis of my clientele, don't need that. So I don't think there's a divorce industry as such. Certainly divorce is high. I think the statistics are underrated because it's possible to get statistics on divorces, but what proportion of people who live common law separate and don't go the same route, although they have to file documents as well quite frequently? How many common law people just split without going to court, just resolve themselves? I don't know. So they talk about, divorce being 40 to 50% of marriages. So if I had any advice to give to young men, if somebody invited me in to talk to all the grads in a high school, I would say, if marriage is 40 to 50% doomed, how many of you would invest your current life savings and maybe the next 10 or 20 years into a restaurant business if the restaurant business was known to only work 50 to 55% of the time? I don't think anybody would raise their hand and volunteer to go into that, and yet love and the great power of the heart puts us into these situations, and we just keep our fingers crossed.
So you'd advise them to stay away from it?
No, I wouldn't. I'm a complete cynic up here, but a total optimist down here. Otherwise, I don't think I could survive, not just in this business, but in life generally. So, as the French philosopher said, the heart knows things the mind knows nothing of. said it better than I did, but it's something like that.
Great. Now, you talked about how there is.
The heart has reasons the mind knows nothing of. I think that's the way it went.
You talk about how there's no information out there as far as father's matrimonial law. When you started, at least there wasn't. Is there a bias though against fathers? Have you seen a bias in the system? And if there is, where specifically do you think it is?
I didn't mean to imply that there wasn't information out there for men who want to go through the divorce process. There has been and there is. What's missing are the help groups. You don't have relief shelters for abused men. You don't have the kind of, or you're getting it now. You're now getting the kind of funding to help prostate cancer that breast cancer has always had. You don't have the psychological support groups for men. And as to whether or not the family law is gender biased, one of the few things I'm prepared to say as a categorical is yes, it is. And it's fascinating to watch some lawyers, and particularly the board of directors of law societies, the governing bodies of law societies, who hate to hear people get up and say that there's gender bias in the courts. All you got to do is ask any single person who's gone through it. Simple as that. There's no, the statute law, the written documents, the divorce laws are gender neutral. And some of the cases suggest that children should spend as much time as possible with their fathers. The bias is inherent in the upbringing of the people who administer the whole system, from particularly the psychologists who do reports. Some of the worst flotsam or drag on the system are psychologists who are looked upon by the courts to give opinions, do custody and access reports. And they incorporate within themselves some of the old-fashioned stuff and don't stay up to tune on what their more sophisticated and knowledgeable colleagues know now. And of course, then the judges. The analogy I use to make the point, particularly to lawyers, because they all admit that I'm right. There is a process in the courts where you can, a spouse, typically the mother, can go to court to apply for exclusive possession of the home. Family falls apart, there's a matrimonial home, and the courts basically kick the father out because he can go and live in his brother's basement or rent an apartment or live on his credit cards or something like that. And the mom and the young kids will stay in the house pending resolution or sale of the house. If there was complete and total gender equality, and if you have two working parents, and you've got kids 6 and 7 who have been raised by both parents equally, and there's no difference between the parties, and if across the country on a given day 100 couples, that's 200 people, 100 couples go into court, and in each case, each is asking for the exclusive possession of the home. If there was gender equality, you'd end up with 100 of the men would have the house, and the other, and 50 women. If I got my math getting screwed up, but it'd be half and half. But everybody I talk to knows that when a judge comes down to that final decision, if everything is equal, the default goes to the mother. Every single time. So the odds of any fathers ending up in the house with the mother, with the kids, and the mom in the apartment or with her sister is almost nil. It's that subtle thing that falls to the woman. And whether that's because our relationship with our mothers, it's in the society. Research shows that women are believed more than men. And even when women, and it's fascinating, when women admit that they've been lying, they're disbelieved more than men who say they've been lying. The bias that is there, and I'm not saying that this is necessarily a good or a bad thing. I'm not trying to be pejorative or judgmental, because there may be, who knows, there may be some evolutionary basis for this which is good in the long run. I doubt it. All I'm trying to point out is the facts, what actually happens. And if you stand up and then say, well, this is bad, and here I'm supporting it, you get in trouble. I personally have been, called on the carpet by the Law Society of British Columbia, or threatened by making statements that the judges are biased. And yet the Law Society of British Columbia, about 7 or 8 years ago, spent a fortune on a royal commission on gender bias in the courts. I mean, they can't go out and put a commission out there trying to look into it and say it's there, and then someone like me comes along and says that dads get a raw deal. Oh, you can't say that.
Now, that was something I was going to ask you about. Are you talking about for the sake of the children?
No,
Oh.
no, that was a
Oh,
different,
that
that was a
was-
parliamentary.
Yeah.
For Sake of the Children was a report that came out of a combination of a group of Canadian MPs and senators.
And can you talk about what happened to For the Sake of the Children?
The For Sake of the Children came out, it's interesting to understand the history of this, because when Rock was the Minister of Justice, he implemented the child support guidelines, which are one of the most unfortunate things which have happened in the law. A lot of people think they're great because they try to regularize. Well, let me back up. The child support guide. This is a different issue. The federal child support guidelines are both good and evil. They're good in the sense that where you have an income-earning parent who's got a consistent and steady job, you can sort of look and say, well, you're going to have to pay this much child support if the other spouse has the kids more often. And this is typically the fathers having to pay the women, And people jump up and say, oh, well, it applies to women as well, That's like, who was it that said that talking about American democracy, was it de Tocqueville that said even the rich can sleep under bridges, but they don't. So we're talking basically about men. So the good part is it gives some guidance, but the bad part of it is, the evil part of it is that once an order is out there, they've got all these little groups in each province, the family enforcement maintenance people who go around, and if you fall back, if you lose your job, you can't afford to get a lawyer to go in and change your order, they'll just keep grabbing you and grabbing you and grabbing you, taking your car, take your driver's license, try to stop you getting a passport, that was all part of it, and drive you into bankruptcy and jail because you can't afford to get it changed. And they'll just stay on you. That's the worst part of the guidelines. They make no, they should have within them some mechanism whereby if a payor's circumstances change, for instance, the mere fact that they might suddenly go on unemployment should be enough to stop the process right there. But oh no, he's got to go and pay lawyers, and that means a lot of money. You got to get into court, takes a long time, and it's killing people, literally. Men are committing suicide because they have been ordered by judges. It's unbelievable that you can stand up in court and put someone's tax returns in front of a judge, all their financial information, and show that they do not have the wherewithal to pay what the courts are ordered to be paid, and the judges say, tough blankety blank, pay it anyway. But they don't do that to women. I've never seen, and there are women who end up paying child support. It's not as if they don't. But I've never seen anybody get pushed. I've never heard of a woman committing suicide because she couldn't pay child support. But men do.
Now, if we can go back to For the Sake of the Children, the report, could you talk about what in very general terms, what the findings were of that report, and then what happened?
For the Sake of the Children, it's been a while, unfortunately, basically said that the courts and society and the laws should look at the rights of children to be parented by both parents. That there should be a concomitant flip side to, if someone's got to pay child support, then they should not have to worry about seeing their kids. There should be enforcement, the same kind of enforcement to parents, again, typically mothers, who deny and obstruct and sabotage relationships between kids and former husbands, the kids' fathers, as there is that force the fathers to have to pay these women. And it was going to suggest, at the committee stage, it was going to actually say shared parenting should be defined as equal time, where the geography permits it. I mean, if you live 1,000 miles apart, good luck. But that was left out. There was a big fight, and that was left out. So basically, it used a lot of these languages to try to loosen things up. It didn't want to use the word access, etc. It got shelved, of course. It had some impact. The shadow, the Chinese say that a good horse will run at the shadow of a whip. Well, it had a shadow effect. The fact that it was out there, and some lawyers, myself included, would start talking about it, I think that the judges moved a bit as a result of that. But it hasn't come down. Another subject that I can throw out here, which is fascinating to me, is the extent to which legislators, both federal and in the provinces, if you meet with them and have dinner with them, or meet with them privately, will tell you that they support fully this idea that kids should have as much time as possible with both parents. They think it should be ingrained in the law, but they're afraid of what they see as a huge female voting bloc out there, which is going to run them out if they do this. And that does not exist. They have become victims of this myth that the so-called women's movement rules the earth. And the vast, vast majority of women are strongly in support of this. As a matter of fact, some of the strongest people that you can get, and you should try to find some, interview them, who support this idea are grandmothers, mothers, wives, and sisters. I get a lot of phone calls as an initial call from a woman who will say, I want you to talk to my son, or I want you to talk to my new husband, or I want you to talk to my brother. His ex is doing this, and he doesn't think he can do this or this and that, or he's been sort of emotionally abused down or whatever. So I don't mean to say that, I'm not trying to stereotype women as being the wrong side of this argument, because they're not. In some respects, for the same reason that women have a lot more self-help groups than men do, in the same way women have probably pushed this shared parenting thing more than the so-called fathers' rights movements who get all the press.
Who is stopping it then? Is the antagonist a myth that people are holding on to, or is there a particular individual in the system federally who's stopping this?
No.
What's stopping it from moving forward?
That's the question. Why isn't change occurring? It's ironic that the judges have moved radically in 10 years on this subject, while the legislators haven't moved 1 inch. As I say, the only thing I can point to is that they're afraid of losing votes, because there was a time when, well, if you go back to when I was in university in the great 60s, which was a marvelous time, and the women's movement started, it was all excellent. It had full support, everybody could imagine. It then kind of got, the women's movement, so-called, in the 80s and 90s got hijacked by the feminists, or what we call the victim feminists. Not the women, not the women's movement, but the victim feminists. And the legislators, the lawmakers, thought that there was a huge block of votes out there they didn't want to offend, and that there were on some subjects, as there should have been. But I don't know what's stopping it now. It's just it either isn't a priority, and it would be so simple to fix. Let me just say one other thing about being clear here. When I use the phrase victim feminist or gender feminist, as opposed to an equity feminist, a woman who wants equality as opposed to somebody who wants rights. When you can tell who they are by if you see a sentence written or you hear a statement made where one of these women and some of the men who support them use the phrase men or man. If you substitute the word man in their sentence and you put in the word black or Jew, and you have a bigoted statement, a statement which would bring down the law against them, then you've got a victim feminist or a gender feminist.
That's very interesting. Could you talk about what your recommended changes are?
Yeah.
If you could sit back.
Don't
again.
do that yet?
And And start by saying that you have some
Okay.
recommended changes and put that in some context.
It would be very easy to amend both the federal Divorce Act and the appropriate legislation in each of the provinces by simply adding in the parts of these legislation where they deal with custody and parenting schedules, to add a phrase that there should be a rebuttable presumption of equal time shared parenting. Now, you may want to cut this out, but it used to be that on property, up until about 20 years ago, within the last 10 or 15, 20 years, prior to that, if property was in the name of the rancher husband, and after 30 or 40 years of marriage, there's a divorce, the wife had to hire a lawyer, spend a lot of money, go into court, take up a lot of court time to prove an entitlement to half of the property. And this is exactly what happens now with children. Men, fathers, hire lawyers, go into court, spend a lot of time and energy, take a lot of time to prove that their children are entitled to have half time with them. Now, we fixed the property somewhat. We've made it easier by simply saying we're going to have a rebuttable presumption. The minute you get married, there is a presumption that your property is 50-50. The presumption can be rebutted if you're married for a year and one spouse brought $1 million into the marriage, the other spouse might get $50,000. After, the law right now is after 7 or 8, certainly by 10 years, it's 50-50 no matter what. So somebody comes and sits down and says, I've been married for 12 years, I don't want her to get anything. You say, hey, she's going to get half. Really? Yep, that's that. Next subject. It's done. If the courts did the same thing with kids, there'd be vacant courtrooms. Now, there's always going to be the personality disordered people on both genders who will precipitate going to court no matter what. So people like me will always have work. But if there's a rebuttal presumption that the kids should be jointly parented on equal time basis, then the presumption falls upon the parent who thinks it should not happen. Now the presumption is on the parent who says it should happen. But if you had to prove it shouldn't happen, you'd have an awful lot harder time. And then of course, there has to be, you have to lay out the various things which the legislation must tell a judge they may not consider as part of why it shouldn't happen. You should not consider the statements of, and again, it's typically the mothers, but it is occasionally the fathers, but it's typically the mothers who say, well, when little Johnny came home from his dad, he cried. In the absence of independent evidence as to what that signifies, or a doctor's report or something, but you simply cannot default back to the women because they say that there's problems or this or that, or bad dreams or these various things. Because the problem is this, and I've seen this, you know, the law says the best interest of the child rules. And that really isn't the best solution. You can look and say, well, the best interest of this child is such and such. Okay. It sort of ignores what's good for the parents and what's good for the family. But we'll leave that aside for the moment. So I've seen judges say the best interest of children is that they have as much time as possible with both parents. And I've seen judges say the best interest of this child is to live with their mother and see their father only once a week. So you can't simply leave it to these phrase words, best interest. You've got to tell the courts what they're not allowed to utilize. The second thing that would be nice to have, which we don't have, is that the lower court judges should be mandated to explain why they did what they did and on what's the evidentiary basis. Because now you go into court and someone says, well, I've heard all the evidence, and I custody to mom, every other weekend to dad, next case. Well, how do you appeal that? How do you deal with that? How do you answer your client? Well, why did I lose? You say, I don't know. If you stand up, if you're brazen enough to stand up and say, well, excuse me, judge, but why did you do that? Well, yeah, that's uncool, although I've done that on occasion too. they'll say, well, we haven't got time, but that'll tie the Court of Appeal up. Well, all right. I mean, either we're serious about kids or we're not.